Hi there. I'm so glad you could join me for my real estate series on wills or no wills. So today we're going to talk about when there is a will and someone passes and how the sale of the property is affected with that, which you would think commonly that's the best case scenario, and that's not always true. My name is Karen Hayes, and I've been in the real estate industry in Texas for over 4.5 decades, and I have closed thousands of transactions, worked with many families in transition pertaining to selling property after someone passes. I have also bought and rehabbed and flipped properties, and in those cases, I purchased that property from an estate, meaning someone passed and usually the adult kids or other family members are selling that property. So I'm quite familiar with how this transaction works. I'm only speaking from Texas, of course, because that's where I've been my whole life. Other states may have similar rules, the same rules, very different rules. So it's always best, of course, to talk to your family attorney, make sure that everything is in place so that there are no surprises when someone goes to sell the property in this situation. We're all going to be in this situation because obviously if we own real estate, and it could be one property, it could be 10 properties or more. The estate, real property, and the distribution of that property is what I'm talking about today. So the scenario I'm going to use is, and here's the simple truth. We're told always you need a will, first of all, especially if you own real property, which is real estate, whether it's land, a home, a farm, a ranch, a beach house. It could just be lots. It could be random acreage property. Whatever your real property is, that should be in your will. And the distribution of that property, meaning when you pass, who is going to inherit that property, who it will be distributed to, is how the will reads. So when you put your will together, typically if you're a married couple, you are naming the other party as the executor of your estate, which is great. That sometimes makes it easy, but at the same time, it depends on how many years go by from the time you created your will and if they're able to still act in that capacity, meaning they can still manage the estate and they understand what's going on and they are of sound mind and can make those decisions that are needed to be an executor of an estate. So that's the first scenario. Two people own the property. One person passed, the other survives them. The person that survives, obviously, if they're entitled to the property, they own half of the property solely. That's their half. Nobody's taking their half. The other person who passed owned half the property. So when we're talking about the administration, we're talking about who inherits the person that passed, who inherits their half of the property. And typically, if you're married, you are naming your spouse as the executor and naming that they will receive your interest in the property so that they become the sole owner of the property. But that's not always what happens. And in Texas, we have a rule of 4 years from the date of death. And in that 4-year period, the property needs to go through the probate courts in order to be transferred to another party. So if the surviving spouse is going to remain in the property and not sell the property, then taking the will through probate, sometimes people think, oh, that's not necessary because dad passed and mom, she already owns it. So automatically his interest is going to go to mom. So there's no need to probate that will. In many states, that's not always the case. And so in order to save money or maybe just needless time doing it, people decide, you know what, you don't need to probate it. It's already going to go to you and you're good. So let's say more than 4 years go by and mom needs to move into an assisted living facility or move in with one of the adult kids, and maybe health has gone bad, or she just decides she wants to sell the house. She doesn't want to be there alone and she's ready to sell it. 5 years ago, when dad passed, the will did not go through probate. Now you want to sell the property, and when you find the buyer and everybody's excited, yay, mom sold the property in a week and it's going to close in 4 weeks and all is great, until the title company runs the abstract search and sees that there are 2 people in title. Mom and dad passed 5 years ago. Dad had a will that should have gone through probate, but did not. At that point, everything stops. Suddenly, the title work comes in, and the first question is, was there a probate of Dad's will? No, we didn't think we needed to probate the will because it was all going to go to Mom anyway. Mom's the executrix of the will, so it should be good. And the answer in Texas is not necessarily. So we needed to establish where Dad's interest went. And showing the will to the title company is not going to change the way title's vested. Normally, after the 4-year rule, it's not easy to transfer ownership, so there's no standard probate that can be done. Also, the real simple truth is you have to explain why you didn't probate, and the court can look at that and say, did you do your due diligence to probate it? And the answer is no, we didn't know we needed to probate the will. So at this point, you are going to have to do something to determine Dad's interest, and the will is not what will be followed after 4 years. So there is a solution, and particularly in a family situation where you're married and one spouse passes and the other is still able to sign documents and move forward and sell, and it's called a muniment of title in Texas. The state decides distribution because the will is no longer being used, but a family attorney can take that will and go to the court, and even though they don't acknowledge it, they could present it, and at that point, the court can ignore that and make their own determination on the distribution of the real estate asset. And this only pertains to real estate, not the administration of the estate in every other way. Cars, jewelry, other assets. That is between the family at this point if the will didn't go through probate. The real estate, the real property, is what we're talking about here. Whether it's 1 property or 10 properties, remember, that will have to be determined. So best rule of thumb might be to go ahead and probate a will when there is a will. The next best thing that could be done in this situation is a muniment of title. And that will allow the courts to make the distribution decisions, and hopefully they'll be made to the spouse, the surviving spouse. The transaction could close hopefully within a few months. It does take time, and depending on the court, depending on the county, and depending on a lot of factors that you don't think about, it's not going to be a fast, let's go get this done in the courts next week and we can close. It's not ever going to happen like that. And in most cases, I've seen it done as quickly as 6 weeks, but typically it's going to be 2 months, could be longer, depending on the county and the court and how busy their docket is and how soon they can get it on the docket to handle this. So keep that in mind. That's a pretty common scenario and situation where you have 2 people that are married, one passes and the other didn't probate. A whole nother scenario is when one person passed, maybe theirs was probated, their interest, and now mom is left with the property and then mom passes. At that situation, the adult children are usually the ones that are going to manage that situation. If for some reason mom didn't have a will, or mom had a will and no one took it through the probate courts within the 4-year period, then you've got the same situation as I spoke of earlier, where the will did not get probated within a 4-year period. And really the only circumstance I've personally seen this happen is when the kids don't understand that there is a limitation, an actual time frame that needs to be met, and one of the kids wants to live in the property and the other kids are in agreement, and or there's only one living adult child of the union and they choose to live in the property. But the problem with that is that just means the property's still in mom's name. And any items that pertain to mom, as far as any tax issues that allowed for a discount for an over 65 exemption or any disability of a veteran or anything that would lower that tax value is on the records. If that's not changed, then there's going to be an issue with that where additional taxes may be due once that all catches up in the end. But just know that it's okay if that's the way you want to go, but at the same point, within a few years, the property probably needs to take the will through the probate courts so that the property can be distributed and sold. If that doesn't happen, and then you've got another beyond 4-year period, then the courts aren't going to recognize the will of mom, and sometimes they'll distribute the property, maybe not in exactly the way mom wished. So keep that in mind. I know this is a lot of information, and we're talking about a common situation, and there's many uncommon situations, and depending on what state, what county, and what those rules are, could actually delay a transaction for months, maybe even years. It's super important that everybody is on the same page, everybody has a full understanding of what happens when someone passes and how the real estate administration can go or will go depending on what's available, with a will or no will. And I will continue the series talking about when there is no will at all, my next video. In the meantime, if I can ever help, I am a real estate agent in Texas, of course. I have a real estate group that has agents all over the world, actually. We are an international company, and I have people that are skilled and educated professionals in other states outside of Texas where I can help you on the consulting part of selling the property, help refer you to family attorneys that can help in your area, as well as a real estate professional that can help you by listing a property where you are, and I can still help you hold your hand, get through these transactions so that you know that you're not alone in this, and I'm happy to do that anytime. So if I can ever help, reach out. I'll answer all the questions and try to work with you in your particular situation, and feel free to comment, ask any questions. I love the comments, and I will get back with you on those answers as quickly as possible. But just know that our belief in that having a will is so important. Yes, it is, absolutely. And that is the one way that you can determine what will happen to your estate when you are no longer here. We're all going to be in that situation. And if you have family, they're counting on you to make sure that's managed. And most of the time, they don't want to deal with it. So let's make it easy on them and get all of our ducks in a row, make sure that our life is organized, which helps them, also saves time, saves stress, and makes for a much easier transaction. Thanks for watching.